Okay, thank you very much. Whenever we're ready, you can let me know. We're waiting still for some participants, I assume.
You can begin now, David.
Okay, welcome everyone this evening to tonight's legal panel, the CLE Parole and Probation panel. We're very pleased, as we've had oftentimes in the past, the honor of having Alan Mills speaking with us this evening. Alan Mills is the executive director of the Uptown People's Law Center, where he represents prisoners throughout the state prison system. Alan began working at UPLC in 1979 as a law student volunteer and has worked there in one capacity or another ever since. He made his first visit to an Illinois prison in 1982 and has been visiting prisoners ever since. UPLC currently has 6 class actions, and correct me, this might be dated at this point, Alan, you'll remind me if I might have missed maybe a 7th, or maybe at this point it might be 3 or 4.
I think we're at 6. We dropped
Okay,
one added one, so I think we're back to 6.
Perfect. UPLC currently has 6 class action cases against the Illinois Department of Corrections, including cases about medical care, mental health care, and the excessive use of solitary. Again, this might be dated, but you had in early 2024, I had mentioned during an earlier speaking engagement, Alan, that you had concluded challenging the way that the Illinois Department of Corrections and the Prisoner Review Board handled parole revocations. In a moment, you could speak further to that if that's dated as well. But I'm very pleased to present this evening Alan Mills. Welcome, Alan.
Thank you. We did do, in fact, 2 cases about revocations of parole, one for the adult system and one for the juvenile system in Illinois. And I'll talk about that later. I wanted to start, however, and I apologize for some of you probably already know all this, but I always think it's important before we start talking about parole to talk about the prison system itself and set sort of a baseline as to who's in prison and why and how many there are. And because that really does drive everything. Because I think the most important thing about the prison system is how big it is. So I hope everybody can see my screen. Should have a nice little chart up there. Okay. So what you can see here is that for most of the U.S. history, prison population has been pretty flat. That all changed in the late 1970s when the prison system exploded. I personally started visiting prisoners in 1982, right at the beginning of that explosion, and I had no clue. I never would have imagined that we would have almost 7 times as many people in prison in Illinois today as we had back in 1982 when I started visiting prisons. It's begun to drop a little bit, as you can see from this. It peaked in about 2010 and then began to drop a little bit, but obviously we have a long ways to go before anywhere near back where we were in 1980. And what people forget is that back in 1968 through the mid-70s, there was a real debate in this country as to whether or not prisons had outlived their usefulness and should shrink. In fact, the United States Department of Justice put out a white paper saying exactly that prisons just weren't working and had gotten too big and we were incarcerating too many people and we should think about alternatives. Obviously, that point of view did not win out. Instead, we exploded the number of people in prisons. So the debate that's starting to happen again about abolition of prisons is really a rerun of the debate that was held now almost 50 years ago, back when the prison system was much, much smaller. So it's not like this prison system that we have today is somehow inevitable. It is, in fact, the result of very specific choices that were made mostly by legislators, but also some by prosecutors and judges. But mainly it was the legislators. It's important, the total number of prisoners has gone up tremendously, but it's broken down. The state prisons are the biggest of that group collectively. The biggest system alone is the federal system. The second biggest by far is California. And after that, various states have a big prison population. The jail population is about a quarter of the people that are incarcerated. Again, Cook County and Illinois in general has dropped the number of people who are in their jails as a result of the bail reform that went through. Cook County Jail is no longer stretched beyond capacity, which it was for about 20 years, with people sleeping 3 people in a cell that was designed for 2. And almost all of the jails in Illinois have similarly dropped the number of people they have, simply by changing the law saying that some offenses are not incarcerable at all while you're waiting for trial, and others the state has to actually prove that you are a danger to be released into the community. So the jail population in Cook County and the state of Illinois has dropped. That's not necessarily true nationwide. The incarceration rate is I think not just actual numbers, but it's the rate that's important to think about when we compare ourselves to Western Europe and look at Western Europe. There's a fair amount of variation. Lots of discussion in interesting criminologists doing these kind of papers about why Denmark has so much fewer incarceration rate than does a place like the UK. A couple of the more popular theories is that Denmark is more homogenous as compared to the UK, which has, because of its history of colonialism, has a lot of different sort of ethnicities, much like the United States has a real racism problem. Also, Denmark has a much more robust social safety net than does the UK. So lots of interesting questions about that. But those conversations generally do not include the United States, because once you include the United States, we're just in a different world. And we really are in a different world in the sense that the United States incarcerates both more, a higher percentage of its population than any other country in the history of the world has incarcerated, as well as more actual people than any other country in the world today, including places like India and China, both of which have far larger populations than the United States does, but their incarcerated population is actually lower. So the United States accounts for about 5% of the world's population, but about 25% of its incarcerated population. So we're just involved in this experiment in mass incarceration, which has no precedent historically ever, anywhere. The prison population is also no longer, if it ever was, hooked to the crime population or the crime rates. And David, I see you're taking pictures. I think you're taking pictures of my slides, but I'm happy to share them afterwards, so you don't have to take pictures off your phone, off your at the computer. I'll be happy to share the slides. You can make an argument that between like 1970 and 1990, the crime rate was kind of increasing. That is the red lines on top of this slide. But since 1990, clearly the crime rate has dropped continuously. You wouldn't necessarily know that from reading the Tribune or watching the nightly news. But in fact, Illinois, or Chicago's murder rate is lower than it has been since the 1960s. And similarly, lots of other crimes have begun to go down and have been in decline for the last 30 years. Nonetheless, our prison population continued to grow. So the prison population, whatever has happened to the crime rate, has just gone up and up and up until, as I said earlier, 2020, when it finally started to drop a little bit. So how did this happen? And I want to talk a minute about the choices we made as to how we ended up with so many people in prison. As a lawyer, the first thing I like to look at is how did the laws change? Well, we had the Rockefeller drug laws, which came in, which imposed heavy mandatory minimums for small amounts of possession of drugs back in 1973, right before this took off. California adopted determinate sentencing. That is, rather than being sentenced to something like 50 to 100 years in prison, and then you got out whenever a parole board said you should, we now have determinate sentencing, meaning that you can only get day-for-day good time or not day-for-day good time. Federal system, it's less than that. For some crimes in Illinois, it's less than that. But at best, you get a day off for every day you do in prison, and then you know exactly when you're going to get out. After California adopted that in 1986, the federal system adopted that, as well as gave huge economic incentives to the states to adopt those sort of mandatory minimums and determinate sentencing. The feds agreed to pay a big chunk of the cost of building new prisons if states all adopted the California model of determinate sentencing. Reagan then put in a zero tolerance policy. So Nixon coined the words war on drugs, but his war on drugs focused much more on diversion and treatment rather than punitives. It was like 90% treatment and 10% punitive. Reagan reversed that, and it became 90% incarceration and about 10% actual attempts to treat drugs and drug addictions. As I said earlier, the mandatory minimums came in. Truth in sentencing came in the federal system in 1994, getting rid of most of the good time you could get and all of the discretionary parole that you could get fairly early on. So those are kind of the things that began to drive sentencing. And of course, there were individual states did individual things to increase penalties for particular crimes, to create new crimes, et cetera, et cetera. That began to change a little bit in 2020, I'm sorry, 2000, the early 2000s or late 2000s, when in New York, which started all this with the Rockefeller drug laws, repealed the Rockefeller drug laws. And the second big drop was in California, where the United States Supreme Court ruled that their medical and mental health care was so bad and was caused by overcrowding that it could not be fixed. And the only solution was to send people home in order to get good medical care, in order to provide medical care that met constitutional minimums. So it's been the courts and it's been the legislatures that drove the increases. That's sort of my lawyer answer, but I think the more interesting question is, why did all these laws get passed? And that, I think, has more to do with what was happening in society and the way it was spun. So there are a series of events that really led up to this mass incarceration. Right here in Chicago, we had the so-called riots around the Democratic Convention back in 1968. A couple of years later, we had Kent State, where National Guard killed a number of protesters. A couple of days later, we had Jackson State, which was almost identical to Kent State, but not celebrated as much because it's one of the historical black colleges, where it was middle-class white kids who got killed at Kent State. 1971, a year later, we had the Attica Uprising. And then 2 years after that, we had the Wounded Knee Uprising. So there's two ways all of those events could have been sort of thought about. One way is we now know that most of the violence done in each of those events was done by the state, by police, by guards at Attica, by the FBI at Wounded Knee. So one possible way to look at all this is, gee, we really ought to have better controls over the state's use of force. But there was a competing narrative, which we now know because of Heather Thompson's book about Attica, was very specifically planned out after the riots in Attica, which was that there's a segment of our society which is just so different than the rest of us that is just like animalistic. And the only way to control them is to lock them up under harsher and harsher conditions. And we know that that was a plan that they came up with, is how to spin that after the Attica uprising, where they announced immediately that the reason they had to go in is because the prisoners were slitting the throats of hostages, were emasculating the hostages, were going to kill all the hostages. And it turns out that all of the injuries to the hostages as well as to the prisoners were done by guards taking it back over again. So all the guards there died of being shot by the takeover, and the prisoners didn't actually harm any of the guards at all. But nonetheless, this narrative that you have these out of control prisoners who just kill people at will sank into the public consciousness. And that, I think, is what really drove mass incarceration, is this idea that somehow there's a group of people out there which we are going to label criminals, or for youth, we started talking about super predators, who just can't be reformed and are somehow different than all the rest of us. And therefore, the only solution is to grow this prison industrial complex like it is. And that's what happened. And all of those things happened right before the huge takeoff. And I have to say, race had a lot to do with this. We have a conversation between Nixon and Rockefeller during Attica, which we know about because Nixon did us all the favor of taping all those conversations. And basically says, all those prisoners were actually, this was led by the blacks, right? And Rockefeller says, sure. And therefore Nixon says, well, then you won't have a problem. So this idea that race should be part of this conversation, should be part of the way we spend this, has been there from the beginning. Another piece of this, which is often, I think, given way too much credit in the press, is the privatization of prisons. And I want to be really clear. I think private prisons are terrible things. They shouldn't exist. I believe they're unconstitutional. But at a minimum, I would say taking away someone's freedom should be hard to do, should be rare, and should never be somebody's profit motive. Should never be anybody's business plan. But they're not. But private prisons are not driving this system. I think Ruth Wilson Gilmore, one of our authors that talks about abolishing prisons, calls them parasites on the system. So they're little worms that come in at the bottom and feed off of the much bigger mass incarceration. So they make some money, but they are not driving the system. They are sucking a little bit of money out of the system. And that becomes clear when you talk about where is the money going. Oops. So the total amount that we spend on corrections, leaving aside the judicial side of things for a minute, is about $80.7 billion. By far the largest chunk of that goes to public employees, so we're mainly talking about guards. This is a really long chart, and I couldn't get it all on one slide, so the next slide will be the bottom half of that chart. And when you get down to private prison profits, you can see it's only 0.37 billion, $374 million out of, well, you may remember, was $80.7 billion. So clearly those profits are not what's driving the entire system. It's a tiny bit of money pulled out of it. I think a much better explanation for this, or at least a factor that made it possible, was racism. When you look at the disparities of who gets locked up in this system, it's astounding. So the blue lines are the risk of imprisonment by white men, and the red lines are risk of imprisonment by age 35 of black men. Two things to point out about this chart. One is that first red line, which is high school dropouts, is over 50%. So we in fact incarcerate over 50% of young black men who drop out of high school. The other interesting thing is the gap between black and white remains almost exactly the same, whether or not you're talking about college graduates or high school dropouts. It's about a 5-to-1 ratio. So if you're graduating from college, there's no question you're going to spend a lot less. You're less likely to go to prison, but the gap between black and whites still remains about 5-to-1, and therefore it is a system which isn't about class and isn't about education. It's purely about race. The racial disparities is not new. If you go back to 1926, the top line here is the black rate of incarceration, not numbers, but rate. And the bottom line is the white rate of incarceration. And you can see that even back in 1926, there was a gap. And that gap remained about the same until this late 1970s, where it exploded. And you can see the explosion is almost all black people. So this experiment, mass incarceration, that we've been engaged in for the last 50 years, is really and truly an experiment on young black men. Drug possession, we arrest huge amounts of people for drugs every year. That is by far the biggest driver of people going into jails. It is not, however, the majority of people who are in prisons. So a lot of people are talking about, well, we should at least get out of prison those people who are there for simple drug possession. You could do that, and the United States would still have the highest incarceration rate in the world. So you really have to talk about not just drugs, but you also have to talk about what are commonly known as violent offenses. Again, just another figure on that. Even the drugs crimes, though, are racially biased. The dark blue lines here are who uses drugs based on surveys that are done periodically by the Department of something or other, SAMHSA, I can't remember what it stands for. Some United States department does regular surveys of people as to who uses drugs. And it's about the same among all races in the country. So about 75% of the population is white, and about 75% of drug users are white. When you look at who's incarcerated for drugs, however, it's exactly flipped around. We incarcerate only about 30% of the population who's incarcerated is white, even though they constitute about 75% of drug users. Same for blacks, even though they only account for about 15% of the drug users, they in fact account for about 45% of the people we incarcerate for drugs. Same with Latinx, they're a little bit less skewed than the black numbers are, but they're very much, again, flipped compared to the white people. I'm going to skip ahead a little bit. So this is a Pontiac cell. This is a cell in Pontiac Correctional Center. As you can see, it's pretty barren. It has this nifty little toilet sink combination, which I always have to point out, there's no lid on the toilet, which means when you flush, there are particles of bodily waste that go across the cell, including on the bed and including on the faucet above. That's why toilets have seat covers, so that you keep all that stuff inside the toilet. They don't have those in prison. Your sink where you get your drinking water is right connected to your toilet, and your bed is right next door to the toilet as well. These are pretty barren cells. And the reason I show you this picture is to emphasize that we don't have to build prisons this way. Norway and many of the other Scandinavian countries have a very different model of prisons. This is a typical Norwegian prison cell. It looks a little different. This is also a maximum security prison in Norway. And the difference is that they have a very different philosophy of what causes crime. In the United States, as I said, our basic theory is that people who commit crimes are somehow different than the rest of us. And the way we prevent crime is to lock people up for really, really long times under really, really harsh conditions. And then that'll somehow dissuade people from committing crimes. Many of the European countries, and certainly in Scandinavia, have adopted a different model, which is that the reason people commit crimes is because they become disconnected from their community supports. That the reason most people actually behave is not because they're afraid of going to prison, but because they're all part of a community and they recognize that if everybody follows the rules, then everybody's better off. If you think of a family, hopefully the kids are not behaving themselves because they're afraid of being locked in a closet. They're behaving themselves because they're part of a loving relationship with their parents and their siblings. And that's sort of the theory of Norway. And therefore, prisons look different. The purpose of prisons in Norway is to rebuild those social connections. So prisons are very small. This is about a 100-unit prison, 100-person prison. It's in a town. It's not in the middle of nowhere like Illinois prisons are. And people live communally. So there's not like a cafeteria you go and they slop stuff on your tray. Prisoners get together, they plan a menu, the guard goes out, buys the stuff, buys the whatever the ingredients are, brings it back. Prisoners cook it for themselves. If they don't cooperate, they don't eat. So it's a way of building a society within the prison. And most prisoners, at least after they've served a little bit of time, go home on the weekends. And most prisoners, again, after they've served a little bit of time, have a job, but not a job inside the prison like painting the prison walls, a job in the community. So the theory is by the time they are done with their sentence, which is much shorter than they are here in the United States, they will have rebuilt those societal connections and are ready to come out and plug back into society. We isolate people for their entire sentences and then throw them back out and say, you're responsible for figuring everything out on your own. And not surprisingly, we have like a 50% recidivism. Sentences are also a lot shorter in Scandinavia. The longest sentence you can get in Norway is 20 years. You may remember the Nazi that went in and slaughtered 70-some kids in a camp. His sentence was 20 years, the maximum they could give. Now, they do have the right to go back at the end of those 20 years and try to prove that he is still a danger. But the burden of proof there is on the state to show that he is still dangerous and has to be recommitted. A more typical sentence is 5 years. That's a long sentence in Norway. That would be sort of what you get for a murder. Anybody who spent any time at 26 in California or criminal courts here know that they hand out 5-year sentences as if they're candy. That's like they're handed out every day, multiple times a day, all over the place. So, the minimum here in Illinois for any kind of murder, a simple murder, is 20 years. The maximum in Norway for slaughtering 70 kids is 20 years. So it's a very different philosophy, very different sort of prison system, and frankly, it works. So that's sort of my background here on the way the prison system works, or the way we built it. I now want to talk a little bit about parole and revocation of parole in particular. The courts have made it, at least in theory, clear that you're entitled to due process before you can be reincarcerated. There's two problems with that. First of all, the courts have chipped away at exactly what that means in terms of due process. It's not like you get a full hearing where you get a right to a lawyer and to cross-examine witnesses, et cetera, like you would at a criminal trial. Parole revocations in Illinois were extremely cursory, to say the least. Basically, it would involve reading the charges that your parole officer made against you, assuming they were all true without any evidence at all, and then you had a right to explain why you thought you shouldn't be reincarcerated or why you thought you're innocent. And the vast majority of people were, in fact, violated from parole and sent back to prison or had harsher conditions put on. The United States Supreme Court had held some 40 years ago, may not get the dates exactly right, that people who were facing revocations of parole were entitled to a lawyer unless in any case in which either they couldn't reasonably represent themselves, they had some sort of mental disability, so they couldn't do it, or where the defense was a little bit complicated. So a simple example of that would be someone on parole who has a mandated to go to a psychological counseling for something, or alcohol treatment. And he says, yes, I went. And the parole officer says, no, I didn't. He's sitting in a jail cell. How is he going to prove he went? But somebody on the outside could go to the place, and usually you sign in and could get copies of those sign-ins and present those to the board. So that'd be an example where it'd be very hard for the prisoner locked up or the parolee locked up, waiting to represent themselves, and a lawyer would do a lot of good. So despite the fact that this decision by the Supreme Court was out there 40 years ago, in the intervening years, Illinois had never appointed a lawyer to represent any prisoner who was facing a parole revocation, ever, not once. So we sued, and now there are lawyers who represent adults, although they're not appointing them nearly as often as they should be. So I won't say that our case was 100% successful, but at least now there is a mechanism where they're supposed to do an individualized assessment to see whether or not you get a lawyer appointed. We had a companion case for juveniles where we made the same arguments. And there the state agreed that every juvenile would get a lawyer because kids really shouldn't be left to represent themselves in these proceedings. There may be an occasional kid who could do it, but the state figured that it was easier just to give everybody a lawyer than it was to try to figure out who was and wasn't entitled to a lawyer. So now all of the juveniles who are facing parole revocation are supposed to have a lawyer. They can waive it, but they have the right to a lawyer. I say it's on paper because, first of all, as I said, they don't really follow it. They don't really appointing everybody they should. But the other point that makes this even more difficult, I think, psychologically, is that what happens is you're violated by your parole officer. You are picked up. You are driven to the prison or the jail, and then the hearing is held after you're already locked up. So psychologically, what members of the parole board, I think, tend to think about is this person safe enough to release, rather than is the evidence good enough to justify locking them up? Because, of course, their decision really is going to be sentencing somebody home who's now incarcerated. Even though there's no legal determination that they should be incarcerated, they are in fact incarcerated. So a lot of parole hearings that I sat in on, you could see the discussion was, well, I'm not convinced this guy is going to make it on the outside, so I'm going to keep him in, with no discussion at all as to the evidence proving he violated parole. It's all about whether or not you think he's good enough to get out. And in fact, one parole officer told me what he doesn't believe in evidence. He looks into the eyes of the parolee and reads their soul and decides whether or not he thinks they're going to be good people or not. And that's not the way that due process is supposed to work. So, we have a real problem with due process in terms of violating parole in this country, and it's not particularly good in any state. There's no state that has a good, robust system of appointing lawyers to represent prisoners, other than California, where a similar case was won, and the state there for adults did what they did here for juveniles, just said, no, we're just going to have the public defender's office represent everybody who's facing parole revocation. So everybody in California gets a lawyer. So I think that's where I'm going to stop my presentation. And I know that in the past when I've done this, lots of questions and comments out there. So this is probably a good time to stop that and turn it over to the audience. I can talk forever about this stuff, but I know you guys have questions. So I don't want to just monopolize my talk.
Okay, we have everyone muted. I don't know, Ellen, if you want me to give them the opportunity to unmute. I had asked for questions in the chat, and well, there's a couple.
Yeah, we have Beth raising her hand, I see.
Okay, before we get to Beth, let me just do the ones that are in the chat.
Okay.
Overall, not by rate, are there more white males in prisons?
Are there? You mean the actual number?
Yeah.
It's going to vary by state. So Illinois, the answer is no. Other states, the answer is yes. It's going to vary by state, in part depending on what the percentage of minorities are. For example, and also interesting. So like a couple of states like Vermont, Maine, maybe Wyoming, have very few Black people in their prison system, but that's because there are very few Black people living in those states. And they also, interestingly enough, have the lowest incarceration rates. The highest incarceration rate is Louisiana, which is a very large Black population, and its prison system is overwhelmingly Black, both in numbers and in rates. Does that answer the question?
Yeah, the other question that was in the chat was about the crime rate, and I think David answered that it's definitely much lower in Norway than it is here.
Yes.
And actually, I will turn this over now. David, if you can just manage looking for people raising their hands and calling.
Yes, I see Beth has her hand raised. Beth, if you could please ask your question of Alan.
Unmute her.
Beth, I think you're muted.
Muted. Okay, now I'm unmuted.
There you go,
Yeah,
Beth.
I have a couple of questions, but the first one is, what happens when, I know in Illinois, in order to get off of parole, and I'm not sure if this is exclusive to people on the, sex offender registry, but they have to take a polygraph, and if they flunk the polygraph, even if they tell the truth, which is possible, they can't get off parole. What do you
Right.
do about that?
I mean,
How do you,
there's, I mean, obviously you can challenge that in court, but it's going to be hard. The problem is that some offenses, and these are the ones you're talking about, have lifetime parole, and it's up to the parole board when you get off. Most crimes in Illinois have a 3-year maximum on parole. So there it's just a question of whether or not you're going to get off early. And in order to get off early, the prisoner board can do whatever they want in terms of there's no right to get off of parole early, obviously. But for those people who have lifetime parole, which are all sex offenders, there's nobody else who has lifetime parole. It is very arbitrary as to when somebody gets off of parole. And it's built that way intentionally by the legislature. As far as the legislature is concerned, people can be on parole for the rest of their lives. And that's really based on this myth that people who commit sex offenses are always going to commit sex offenses, and no such thing as a reformed sex offender, which again goes back to the press. I mean, if you read if you watch shows like Law and Order SUV, that's sort of the theme that's underlying many of those shows, is that somebody who commits a sex offense will always commit another sex offense, and therefore they should be on parole for the rest of their lives. That is not true at all. The highest recidivism rate is among drug users and other nonviolent offenders, and sex offenders have almost the lowest recidivism rate there is, other than murderers. Interestingly enough, have the lowest recidivism rate. I see Mike has a hand up.
Thank you.
Mike, are you able to unmute?
Yeah, I think you have to do it from here.
Mike Cooperman does have his hand raised.
Yeah, I'm asking him to unmute, but Mike, you need to unmute yourself. There we go.
Yes, here we go. He's fine.
Yes,
Go ahead.
Thank you for allowing me the privilege to unmute. Thank you so much, Mr. Mills and Adele Decalogue, for being here and providing this important information. And I had the privilege of seeing you do it, a very similar presentation last time, but I think it's very important to refresh. As regards to the polygraph specifically, in the spirit of cooperation, I am a registered citizen as well. I have the honor and privilege of working with Forhinda. Thank you all for coming. And I've had a lot of experience, but I'm not going to name his name, but Abby knows who it is. We have a fellow staff member who is magnificent, utterly magnificent at explaining how the polygraph is essentially junk science. And the courts know this perfectly well. And as Mr. Mills said, it is absolutely a deliberate act that they created this carve out not for sentencing, not for purposes of determining guilt in a procedural process, but for determining guilt by a parole or probation officer for sex offenses. And what I've learned is it is almost entirely used as a tool, allowing arbitrary and capricious judgment by that officer who oversees his or her charges to exercise power over them. So they may have zero evidence, right? And essentially it is a motivational tool. it is a stick among many other sticks they have to try to ensure compliance by scaring people scared straight. If everyone remembers that program, Mr. Mills, since you deal with youth a lot, you probably remember it pretty well. This is
Also, remember that it was proven to be totally useless.
So it is interesting. My attorney told me that there is the law and then there is the sex offender exception to every aspect of the law. When most people think of the law, I certainly grew up thinking that it was sensible, it was coherent, it was consistent, and if there were any problems, it was responsive to a healthy feedback loop whereby the voices of the public and misapplication would be entertained by the courts, entertained by legislators, and that proper adjustments and changes would be made. What I've learned, and I only have a very elementary understanding of this compared to Mr. Mills or others in the legal field, but that very little of that actually is true. It is it is a corrupt process, like unfortunately many other processes in our various systems. So, not to sound totally cynical, I mean, I'd certainly rather be in America than almost any other country. There may be some European countries that would be a little less restrictive, but overall, we have it here pretty darn good. I do consider myself a patriotic American. I do consider myself a fan of America overall, but that does not mean to say that I think that everything is done here well. So I'm going to stop talking because there were some questions in chat from Ms. Alfano and Ms. Murphy. Thank you.
And I just want to say one thing about your cynicism in terms of the legislature correcting things. I talked to a couple of Republican legislators who are the ones who are really pushing for this lifetime parole. And at least one of them, who's also a lawyer, admitted to me saying, I know this is useless. I know it doesn't do any good whatsoever. It doesn't protect anybody. But my constituents all want it, so I'm voting for it, even though I know it makes no sense whatsoever. And that's why I'm elected, is to represent these constituents. So they think it's a good idea, so I'm voting for it, even though it's wrong. So you're absolutely right. This has nothing to do with evidence. It has nothing to do with whether it works. It has nothing to do with anything other than satisfying the public and just sort of knee-jerk reaction to it. And this came up much more recently in Cook County, where, as you may or may not know, there's now a Just Housing Amendment, which says that in general, it's illegal to discriminate in housing against people with criminal records. But the big exception is sex offenders. And I've asked the commissioners and our now mayor, who is pushing that, it's like, why in the world did you accept sex offenders? There's no evidence that they're treated any differently. And they're like, because otherwise we couldn't get a majority of people to vote for it. We had to do it in order to get a majority. And without a majority, it's not a law. So again, it has nothing to do with reality, it has nothing to do with evidence. It's just pure, not even, I want to say politics. It's just pure sort of knee-jerk reaction to the prejudices of the public. Sorry, I didn't mean to interrupt the next person.
Michelle, would you like to ask your question or would you like me to ask it for you, Michelle? Michelle was asking about civil commitment in Illinois, Alan, in the Midwest. If you can speak to that a bit. And nothing more specific, but that was the general question.
So I'll talk about Illinois. I can't talk about other states because I don't practice there and not licensed there and don't know anything about them. But in Illinois, there's two different sorts of civil commitment for sex offenders. For sex offenders. First, there's the after you've served your sentence. If somebody thinks that you're still going to be dangerous, then they can petition the court to have you civilly committed, and then you are sent to Rushville, and you're held there until a judge determines that you're cured, in big quotes. The problem is, of course, that the people who are providing the treatment at Rushville don't believe that anybody can ever be cured, and therefore, at least for many years, more people have died at Rushville than have been released. So it ends up being a life sentence put on top of what is often a long sentence that people already served. There is a second kind of civil commitment in Illinois, which is more of a diversion program. That is, before you've been tried, the state attorney can ask to have you civilly committed, and then you're sent, oddly enough, to the Department of Corrections, even though you haven't been convicted of anything, housed at Big Muddy. And again, you're there until you are, quote, cured. And again, almost nobody is. And the treatment there is, if anything, even worse than it is at Rushville.
Thank you, Alan. Before we get to Michael's question, Melinda had a question, and I'm going to somewhat interpret it, but she asked, looking for research on polygraphs in individuals on the autism spectrum. I think what she's really asking is, are there any new cases that you're familiar with on that subject that would be instructive on
Yeah,
that?
I responded privately to that, and the answer is no,
Oh,
I
okay.
don't. But there are, I work with somebody who has done some, a lot of work on autism, and I'll be glad to send her the information afterwards.
Okay, perfect. And Michael, if you can unmute your question, we're ready for your question, Michael. Michael Lemberger, yeah.
Thank you. Thank you for addressing civil commitment. I am a person on the registry as well. I was also subjected to civil commitment in Illinois. I was at Rushville for 12 years.
Congratulations.
I was at Rushville longer than my original sentence. I did more time than my original sentence. I ended up doing 30 years on a 24-year sentence. The laws, I'm glad you addressed that, because the laws surrounding civil commitment are vague and opaque. There is no transparency in civil commitment. Like you said, Alan, it is directly and specifically designed to incarcerate you for the rest of your life. Getting out is a very large door and a very small window. I was there. Civil commitment is not a good idea. It is not a deterrent. It does not help. I had to lie in group in order to get out of the facility. I had to tell lies about crimes that I never committed, and I had to admit to crimes that didn't exist. It's just a travesty of justice. So I'm glad that that was brought up. Thank you.
And let me just add to that a little bit. A number of years ago when they first started doing this, not in Illinois, but nationwide, two different cases went to the Supreme Court challenging this as double jeopardy, which it clearly is. You've already been convicted and served your sentence, and all of a sudden you have to serve a new sentence. And the Supreme Court has said, sorry, it is not actually a penalty at all. It's a protection for society, but not meant to be punitive, and therefore it doesn't fall under the double jeopardy clause. I think that was an absurd ruling, and a lot of other people did too. Back when we had a reasonable shot at the Supreme Court, there was an effort to try to bring this back again. Now that we have a lot more evidence of just how punitive civil commitment really is. But unfortunately, I don't think this current court is the place to try to bring that case. So I don't see any end to civil commitment as it's currently practiced anytime in the near future.
Abby, I believe you had a question, if you want to unmute.
Yes, and there's somebody named Mr. Purple who's before me. So I'm going to let him go if he'd like to ask his question.
Okay. Do you have a question, Mr. Purple?
There.
I like the color purple, so that's
There
Put
we
it in
go.
the chat, I think. Oh, sorry, go ahead.
For a second, it said the host wasn't allowing me. Mr. Purple 1972 is my email, so that's why that came up. But I'm James Heinemeyer. I attended the first three, and I'm so thankful to Hinda and the Decalogue Society, and Mr. Mills, Mr. Grosky, Mr. Cooperman for all this. Thank you, Abby, for recognizing my question. My question is really about my personal situation. Again, a person on the registry, served 3 years in prison. I've been out to following all my rules, passing polygraphs, passing drug screens, doing everything right, attending my programming, putting forth my best effort. But for some reason, because I have an appeal, and a very meritorious appeal, the DOC-DCC views me as a denier. And so I am on severe restriction. It's not named a house arrest, but it's actually just every bit, if not more restrictive than a house arrest. I'm verbally abused. I'm threatened on a week-to-week basis. And, they really hold all the cards. So it's a perception problem that I don't know how to really change. And I've been patient. I don't know that there are any answers, but are there any suggestions, either from our speaker or from the crowd on, how to dismantle, really some of the abuse that is ongoing? Thank you.
Let me just, this really, I think, is really the same point that Michael made a minute ago. In order to often get off of parole or in this situation, you have to admit responsibility even if you are contesting your innocence. And that isn't just for sex offenders. It's often true for some of the old, Illinois still has some C numbers left. That is people who were sentenced pre-1978 to indeterminate sentences. And there too, if you go before the parole board and you contest your underlying conviction, even if you claim you were tortured by the police, which we now know there are hundreds of people who were, you have a very hard time getting a vote to be released because you haven't, quote, taken responsibility, quote, for your crime. And that's one of the things they want you to do, even if you're denying that you ever committed the crime, even if you have a valid appeal pending. They often say, well, we want to see remorse. How do you show remorse for something you say you didn't do? So, I think that ultimately, the only way some of these problems are going to be solved is if we have a better parole board. And that certainly is an issue in Illinois, where our governor tried to put some more progressive people on the board, including for the first time ever, a formerly incarcerated person. And the Illinois Senate refused to affirm any of those people to allow them to sit on the board. And therefore, the governor put up the next batch they put up were quite conservative. So, I think until there's a popular movement that doesn't say just tough on crime and actually pushes back some and says, this parole board has to actually be balanced and actually listen to evidence and those kinds of things, it doesn't matter so much what the laws are because they have so much discretion, particularly with sex offenders, but not just with sex offenders. They have so much discretion that as long as people who are on the board have this attitude, then it doesn't matter what you do, you're not going to get off parole.
Thank you. Thank you, Alan.
I'm sorry, I don't have a better answer, but I don't want to
Other
give you
questions?
Yeah, I just wanted to say something. I wanted to comment on something, Mr. Mills, is that I think the problem begins in the courts, where not over 80 to 90% of people are pleading guilty. And so we think they have a right to plead innocent, and they actually don't. They cannot afford the lawyers. They're scared of jury tax, of getting longer sentences. So that begins to fill the prisons. And once they plead guilty, the prosecutors have so much power that they throw everything at them, and then it hits the papers. And then prior to that, we have no mental health institutions. So people are being incarcerated for what are essentially mental health issues, huge amounts. And then once they're in, there's no treatment in the prisons. And then when they get out, there's no reentry plan. So it's a huge cycle. And I just wanted to point out that it's a cycle that goes beyond parole and probation. I mean, I'm new to it, but it's just horrifying, really. At HINDA, we're trying to fight it, maybe not politically, but at least through support, reentry plans, and trying to support the families and the people through the criminal justice process. And it's horrifying, really.
I do want to push back a little bit on that. I don't think it starts with the courts. I think it starts with the voters. We just had an election here for state's attorney, and the less progressive state's attorney won that election. And if you listened at all to her speech yesterday at the inauguration, it was all about being tougher on crime. It was all about locking more people up. And that's the person who won the election, not the person who said they were essentially going to continue the Kim Foxx version. So a lot of it, prosecutors have not just after people plead guilty, which is what you said, but often they're overcharging. Prosecutors can charge, they have a lot of discretion as to who they're going to charge and what they're going to charge them with. Many actions can cover 3 or 4 different crimes, and prosecutors have the choice of whether or not they're going to file at all, let alone whether or not they're going to file the maximum charge or a more minimum charge. And once they do that maximum charge, then there's a huge pressure on people to plead guilty, particularly if that maximum charge means they end up imprisoned in Cook County Jail or whatever jail, waiting trial, which is a horrible place to be. So, I mean, I've seen so many people plead guilty because they said, I got to get out of the jail. It's just a terrible place to be. And if you didn't detain people, the statistics are very clear. If you're not detained, you have a much better chance of having not to plead
Right.
guilty, as well as if you go to trial, winning the trial. So the decarceration is really important pre-trial.
Yeah.
See bad-
I'm hoping that, just last sentence, that at some point will be solutions based
You broke
and
up.
not
Yeah, you broke up, Abby, if you could repeat that.
based. So,
Okay, let's move to Beth. Beth, you have your hand raised. You can ask your question, please, once again. You're muted.
Hi, thank you. Yeah, I have some questions about expungement. I mean, what does it take to expunge a sentence? And what exactly does it mean? Who still knows about it? Does it impact employment? That kind of thing.
So Illinois has two different processes. One is actual expungement, which means that the records go away entirely. And that only applies to some fairly select number of crimes. A much bigger selected set of crimes are subject to what they now call sealing. Sealing is important in that it means that people like employers, people who do credit checks, those kinds of people could not access it. Who does still have access to a sealed record is law enforcement. So the police have really made an argument that we want to be able to know when we pull somebody over whether or not they have a criminal record. It's really important to our own safety to be able to know who has a criminal record when we're dealing with it. Even if employers have no business with it, landlords have no business with it, the general public has no business with it, we, the police, ought to know. So the legislature has sort of split that by making a lot of crimes eligible for sealing and only a few crimes eligible for actual expungement where the record just disappears entirely. And even the police don't have access to it. And how you go about it is that if you are in one of those qualifying crimes, you file a petition with the Circuit Court of Cook County, or whatever county you're in, and it goes before a judge, and the judge decides whether or not it meets the criteria. That is a much easier process to do with a lawyer. We don't do that here at the Uptown People's Law Center, but Cabrini Green Legal Aid does hundreds and hundreds of those every year. They are the specialists in that. And they're a bunch of private lawyers.
I have a follow-up question. If you have a sealed record, and you're applied for like a government job, will they be able to find it?
No.
Okay. That's good. Good to know. Okay, all right. Thank you.
Thank you,
for
Beth.
the answer.
Thank you, Beth. Further questions for Alan?
See one in the chat there from Rabbi Scheinman.
Is it a law or a state regulation that registered citizens cannot go into assisted living or nursing homes? We know that that's a struggle. His question is there a particular regulation? Or law?
Interestingly enough, so this is an issue we're really interested in terms of non-sex offenders again, because our position is, at least in Cook County, it violates the just housing amendment.
Okay,
that is
quiet.
a housing decision.
Quiet.
That's in fact a housing decision, and therefore the nursing home should not be able to discriminate against people with criminal records. Period. Unfortunately, as I said before, that excludes sex offenders, so it's not going to help anybody with sex offense. I think the short answer is it is more a policy of nursing homes. It is not a overall rule or regulation. And the reason is because they don't want to have to notify. What is a rule is that they have to notify neighbors, meaning everybody else who lives in that nursing home, and their families have to be notified. And nursing homes are, I think, quite reasonably concerned that if they send out a notice to everybody saying that, hey, we have a sex offender or a murderer living here, then they will lose a lot of business.
Hey, I have a question. This is regarding the Safety Act, and by the way, we're going to be doing a CLE later in 2025 on the ramifications of that. But have you found that that impacts at all the number of people who are being held in pretrial detention, and if is it more or is it less? And if it's less, does that put them in a better position to not feel that they need to take a plea when they haven't actually committed a crime?
Yeah, I think you may have joined after I talked about this a little bit, Aviva. But yes, certainly in Cook County, the number of people who have been subject to pretrial detention has dropped pretty significantly. Most counties in Illinois it has dropped. A few counties it has not. And interestingly enough, what many of us are concerned about is that the pretrial detention would simply be replaced by electronic monitoring. And it turns out that at least as of now, at least in Cook County, the number of people on electronic monitoring has not increased from where it was before. So in general, I think that the Safety Act has had a extremely beneficial effect in terms of people not being certainly pretrial detention, but also has had something to do with the drop in prison population. Illinois' prison population during the pandemic dropped from about 40,000 to about 30,000, a little under 30,000. And so far it is not crept back up again very much. It's gone up a little bit, but it's still about 30,000. And I think part of that has to do with the Safety Act, where people are not being pressured as much to plead guilty and therefore go into prison. But I don't know any figures about the guilty plea part. The coalition, I don't know what it's called, the Coalition Against Money Bonds, something like that, has those figures on its website. I think it's broken down by all the counties. If it's not up here yet, they're working on it.
Thank you.
And by the way, there's no evidence that those people who are out have been committing more crimes than they would have before. In fact, the evidence is the reverse. It seems that there's a pretty good correlation between recidivism rates and being detained prior to trial. The more you're detained, the more likely you are to commit a new crime.
Alan, you might want to take a look at the chat from Stacy Silver.
Oh.
She asked a question just now at the very bottom there, relating to one of your slides.
Yeah, I'm reading. Yeah, truth in sentencing is the one that I talked about. Federal truth in sentencing applied to the federal crimes, and then it included an economic incentive for states to adopt truth in sentencing as well. Excuse me, because getting federal money to support building new prisons and other law enforcement money was contingent upon a state adopting truth in sentencing.
Understood. Thank you.
Thank you, Stacy. Any further questions for Alan? In the chat or otherwise? Michael, you're muted.
There we go. Thank you, guys. My question is there any discussion in the legal field in this very odd and interesting time where
Is there ever not an odd and interesting time, Michael?
perhaps, but this seems particularly odd and interesting in my view. Some may agree. The downsizing of the federal government. Now, usually in my observation, I'm not as old as some, I'm older than others. When downsizing happens, it's usually pretty selective. They go after people in the IRS, they go after people maybe in Social Security, the low hanging fruit. What they tend not to go after so much is the military and the prisons and, the DOJ. Given the extraordinary level of rhetoric coming out of the White House and people like Elon Musk and the DOGE, which is yet to be established as an official office, but may actually happen, hard to know. Is there any anticipation within the legal field that either prisons will be downsized and more consideration would be given to, say, a Second Step Act or a Third Step Act, that type of thing? and that the level of intrusiveness of, for example, a probationary or parole regime would be reduced. That's my question. Thank you.
Yeah, there's been a lot of discussion, and of course, we're all just speculating, particularly because the rhetoric was not in any way uniform on this question. On the one hand, it was shrinking the government. On the other hand, it was tough on crime. Both of those things can't be true. Uh, so, I mean, the big thing about the president during the presidential election was the president-elect often was making comments about how it was easy to solve crime. You just had to unleash the police and they could solve the crime. The problem was people like the ACLU and I suppose us, although we were never mentioned, thank goodness, who were protecting all these rights of these bad people. And if we just stopped protecting all those rights, and then we would solve the crime problem. On the other hand, they're also talking about shrinking the federal government, and obviously there's been a lot of pushback in terms of destroying the FBI and rolling all that back. And of course, the other side of that is that historically, I think it has been very much a bipartisan effort to build this prison system that we have now, or this even beyond the prison system, but courts, legislature, police, all that has been very much a bipartisan effort. And in many ways, the Republicans have actually been better on those issues than have the Democrats. Trump it was Trump who had the Second Chance Act. Biden didn't do anything like that during any of his 4 years. So, I think it's just impossible to predict what this administration is going to do until they start doing it. The other part of that, I guess, is you have the Koch brothers who have been financing big parts of the decarceration effort. Now, some of that is very much so that they could also decriminalize some of the environmental laws out there, which they obviously have a personal interest in doing. But their rhetoric anyway, and what they've been spending their money on goes well beyond that and goes to like decriminalizing drugs, decriminalizing sex work, a lot of those crimes out there. So again, what role they're going to play in this administration, I have no idea. So there's been a lot of talk about that, and just to really, the really extreme version of this is there are at least currently 2 Supreme Court justices and probably more who think that the 8th Amendment shouldn't apply to prisons at all. And that, who knows who's going to get appointed to the Supreme Court in this term. And if that ever becomes the majority of the Supreme Court, then I think that's going to have a very major impact as on prison system nationwide. If the 8th Amendment is eliminated as a tool to try to reform prisons, then all bets are off.
Can I just?
No, I think Stacy has a question, Michael, first.
All right, sure, I'll wait. Thank you.
Stacy, if you can please unmute, you have your hand raised, Stacy.
So a follow-up. So Alan, again, you said that the Federal Truth in Sentencing Act, if states adopted it, then they got money to build prisons, right?
Yes.
So what if we undid that and we as a country made it so that the federal government didn't have to give us money and we shrink everything? Is that a strategy?
I mean, sure, that would be great if you could. Look, every state has a significant part of its prison and its budget in general comes from the federal government, and Congress could condition that money on pretty much anything they want to condition it on. That's the most recent example of that, I think, is PREA, that is the Prison Rape Elimination Act, where essentially Congress said you don't have to do all these things, state, to protect people from being raped in prison, but if you don't, then you lose a chunk of money. And most, but not all states, therefore adopted PREA and its regulations. That doesn't mean they're all following them, but they all did, in fact, adopt it. I think Texas is the big outlier who said, the heck with the federal money, we'll give it up. We don't want to do all this stuff. But I think every other state, or at least almost every other state, has said, sure, we'll take the money and do it. So the bigger question is, could you ever get this Congress to do that? And, I don't hold out much hope for it, given the current, what is likely to be the makeup of the coming Congress. And yeah, same thing with RLUIPA. Jonathan, right? RLUIPA also is a trade-off between taking the money and complying.
Michael, your question? You're muted.
Thank you. So this is just kind of a follow-up, which maybe you might want to fold into future presentations. If the Eighth Amendment does not apply in prisons or is highly qualified, what very much does apply is the 13th, which, if you look at that amendment, allows for prison labor. So that's one issue. And by the way, the conditions of that prison labor is not really subject to OSHA or other worker protections, and I'm sure many people here can speak to that in great detail. The other is just this broader systemic thing about how prosecutorial power works in America. The fast track to power, if you want to be a congressperson or hold higher government office, the fast track is to be a prosecutor, particularly a federal prosecutor. And how does that system work? The greatest number of people who receive convictions for the greatest length of time. That is my understanding. Feel free to correct me. I'm sure it's a very elementary understanding, but that, to my understanding, is a core part of the process. The system rewards people who get the maximum sentence, give the maximum sentences to the maximum number of people with maximum time. I recall very distinctly, I'll finish with this. There was someone who was freed by the Innocence Project in North Carolina. His sentence was overturned decades later. He lost 40 plus years of his life. After it was revealed by the appeal that the prosecutors at the time had withheld exculpatory evidence in contravention of the law, that prosecutor who was responsible for that case said he was completely unapologetic and that he would do it exactly the same way again, which I found fascinating. So the issue for him was not that he sent someone away for decades of his life for no reason other than his own or his office's own advancement. He just fell back on this old banal idea of, well, it's an adversarial system, so you do what you have to do. This shows a total lack of ethics, and I don't know what happened to him. I think he's retired now, so it's beyond the scope of the ABA Board of Ethics. But I just thought that was a very telling story. Thank you.
Yeah, I want to respond to that and want to expand a little bit on what Jonathan just put in the chat about the 13th Amendment. I think you're absolutely right. Even when prosecutors are regularly overturned for withholding evidence, et cetera, almost never is there any consequence to the prosecutor. The number of prosecutors that have been found guilty of ethics violations and certainly the number that have been in any way prosecuted is remotely small. The reason those make the press is because they almost never happen. So yeah, you're absolutely right. Prosecutors are essentially immune to any sort of oversight by the courts or any sort of pay any cost for violating people's rights, and often they get promotions based on the convictions, regardless of whether or not they're overturned later on appeal. In terms of the 13th Amendment, Jonathan put, I think, a very good statement in there, and I think a lot of it depends on the state. Illinois, for example, most prisoners would love to get out of their cells and work. Those jobs are plums, and there's huge competition for them because the alternative is sitting there and staring at the wall 24 hours a day. It's not like there's anything else to do in most Illinois prisons. Other states are very different. If you go to a place like Louisiana, you are required to work, and you're required to work on the cotton fields, hoeing cotton at 100-degree weather 12 hours a day. That sounds a lot more like slave labor. And in fact, the big prison in Louisiana is on a former plantation. And almost all the workers are black. So it looks a lot like slavery. So I think it depends a lot on whether or not those jobs are voluntary, whether there are options there are for prisoners, and particularly what the conditions of that employment are. Not so much the money. It's much more about what you get to do with your day, what the alternatives are to having to work. So I think this question of slave labor and forced labor is really much more complicated than a lot of people are talking about. And I'm sorry.
Michael Lemberger has his hand raised. Michael, if you unmute, you can ask, please. Go ahead, Michael.
Mr. Mills, I just wanted to circle back to the civil commitment issues and, you know, transition into the polygraph. My question for you is, and I'm quite sure, I mean, you're obviously familiar with Rushville and the tools they use, the diagnostic tools, and I put that in quotations.
Right.
Not only do they use the polygraph as a quote unquote diagnostic tool, they also use something was called a plethysmograph. These are just archaic, draconian style tools that they use to justify the continuation of an individual's civil commitment because they have reactions to these tests that are basically junk science. So my question is what, if anything, is being done to remove junk science from the actual diagnostic tool bag that the state uses to have people civilly committed? If anything, this plethysmograph specifically and the polygraph. Thank you.
Yeah, I mean, you're absolutely right about the junk science. One of the ways that it's defended is we don't care about the results of the polygraph. All we care is whether or not people are willing to take it. And that's our truth telling. The other thing that's often used is voice stress analyzers, which are pretty well established, do no better than flipping a coin in terms of figuring out whether or not somebody's telling the truth. Again, the problem isn't necessarily the particular tools that they use. The problem is the amount of discretion they have and the prejudice against letting anybody out ever. There have been a lot of litigation about how arbitrary the system is, and all of those cases have lost, even when it's by very good lawyers and having very good medical evidence to contradict some of these quack doctors they have that they put up who always say nobody's ever cured. The courts just are not willing to let out people who have sex offenses. It's disgusting. Sorry, I don't have better news for you there. I think it's totally unconstitutional and ridiculous. I think the whole system is outrageous and shouldn't exist at all. But unfortunately, again, I don't get to make the decisions. If I did, it would be a very different system, believe me.
Steve Sand. Go ahead, Steve. Unmute, please. You're muted, Steve.
There you
Okay,
go.
thank you. With the way people are treated when incarcerated, and this might sound rather ridiculous, but why not try to say that we have equal rights as animals? And therefore we are an animal, and that would elevate the way we're being treated. I haven't seen anyone try or heard of that. And I see you kind of nodded your head like that's an interesting perspective.
Well, it's one that's argued all the time, and I don't really like that analogy because, of course, people shouldn't be treated like zoo animals. They have more rights than zoo animals. So I don't really like the analogy, and I just don't think it's going to go anywhere in the courts. I mean, the fact that animals are treated better is generally just a question of wanting to. The courts are loath to enforce any kind of rights. Animal rights is a nice little slogan out there, but it's not something the courts actually do much about. So, I just don't think it's a winning argument. I don't think it's going to overcome the current Supreme Court's hostility towards prisoners.
And then I have to say I'm somewhat confused with, like you were talking about earlier, that for a parole hearing, a juvenile gets an attorney. But
Yes.
why is it that they'll take that same juvenile, wave them into adult court, and now we've got this gray area of what rights are what, and it's happening more and more. I mean, here in Wisconsin, they just recently were talking about waiving, I think it was a 10-year-old for a homicide into adult court. So I'm in Wisconsin. So part of the thing is, how do we keep the adult system adult and the juvenile system juvenile?
Yeah, I mean, there's been a lot of pushback about that, and I know Illinois went the other direction for a while, was restricting some of the ways that people could get waived into the adult system. I know Wisconsin has gone the other way, and the 10-year-old is outrageous. No 10-year-old has the same capacities of making decisions and isn't well formed as an adult is. There's lots of evidence now saying that even 18-year-olds and 20-year-olds aren't fully formed in terms of their decision-making abilities. But nonetheless, Wisconsin has decided on a 10-year-old. I would say that the courts have done very little about this and really don't care. The only place it's really affected in the courts has been about the death penalty and mandatory life. But I don't know of any real movement to try to eliminate the ability to waive juveniles into the adult system. And again, different states deal with differently. Illinois, even if you're convicted as an adult, you're still in the juvenile system until you turn 18. Other states, you get put into the adult system if you're convicted as an adult, even if you're 10 years old, which is outrageous. But
Thank you. Thank you very much for being here today.
and I apologize again. I'm giving everybody bad news, but that's because the system is bad. There just aren't a lot of good news to broadcast here.
Maybe you're giving us good news that we are thinking the right way and accepting that the system is a bad system. So that's a positive out of what your presentation. Thank you.
Yeah, it's not that lawyers are just missing obvious arguments. It's the system is really bad.
Any final questions for Alan as we conclude?
I just want to say I thank everybody for coming. I'm thrilled that there are so many people on this, and there's this many people who care about what happens in our prison system. This is, I think that the idea of what really needs to happen in order to save the system is to get out there and educate the public. The public is the one that ultimately drives the system, and the more we can convince the public that the system as right now isn't just need to be sort of jiggled around the edges, and it's not just a question of lawyers not making their arguments. It's the system itself is fundamentally flawed. We have to get that message out there. Until the public believes that, I don't think ultimately there will be a solution to many of these problems. And that's one of the reasons I'm here, is to convince people that they should go out and talk to everybody.
And we hope you're here for a long time doing what you do, Alan. We hope so. Everybody, thank you so much for your attendance this evening. We're very pleased that you could join us. Alan has been a regular speaker for the Hinda Institute. We're very happy that we've been able to introduce him for the Decalogue piece to this. And we're very pleased to have all of you this evening. We look forward to your continued attendance and to have Alan back again to speak as soon as he would be willing to. So thank you all very much.
Do note that the Decalogue link that was in the email wasn't working for me in terms of signing up for CLEs for those of us that are lawyers. Maybe it's fixed now, but
Good point.
didn't work when I tried it.
We'll check that.
Yeah, we'll check that. Okay. Well, thank you all very much. Everybody have a great evening.